morning, everybody. I need a favor, first of all, especially those in the back. Can everybody hear me? So we're okay today, right? Welcome, 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 my friends. You're all my friends. I want to thank you for a couple of different things. Number one, you know how important to listen and to see what you can do, but the evaluations are really important because they really help us. And I want to tell you that 73% of you all here did the evaluations last time, which is spectacular. And you all, thank you, thank you, thank you. You overwhelmingly loved the presentation. Your biggest concern with comments was the sound, and I think we have it corrected. My favorite to you is, as Jim Peterson goes along and talks, if any of you are having a hard time hearing, please raise your hand and we will rectify it immediately. That was the overall riding concern. The other thing that I want to tell you about that you also did was that many of you watched it on television, which I think is fabulous. Because as I said before the first time, don't worry about taking so many notes here, because you'll miss part of the conversation. You can go back and watch the television over and over again so you won't miss anything. So, Nancy and Jim are going to talk about the real nuts and bolts about estate planning, but my question, are we okay? Yes, no, what? Thank you very much. Oh, one other thing I forgot, on your handout, if any of you need more services from Jim, his information is at the bottom, so none of you have to worry about picking up a card. It's all on the bottom of your worksheet. Okay, thank you.
And of course, that was the fabulous Carol Bortman, who is so modest, she never tells you who she is. But I think we all know now. I'm Nancy Ursey, and I'm really glad to welcome you back, most of you back. How many were here before? Okay, it's time to come again, and you know by now that the overall goal of this new Brooksby program, don't be scared, be prepared, is to help us planning our wishes for healthcare and organize us for the end of our life, which we hope will continue for quite a long time, but we want to be prepared. We don't want to be scared. So today we welcome back Attorney Jim Peterson. Jim is an elder law specialist who's been practicing in Salem since 1977, and he strays across the borders to Peabody and a few places around here, including Brooksby Village. So he's no stranger here because he has clients here. He also, his parents lived here at one time. So Brooksy is his home turf in a way. And like the other speakers in the Be Prepared series, Jim is a volunteer with his time and his preparation. Yesterday, he was putting some final touches on what he's going to tell us today. So he's a dedicated fellow. Today, he'll give us an informational overview of some of the legal documents involved in estate planning. He will not give specific legal advice to individuals this presentation, but he will have some time for general questions at the end of his presentation. Our first session on estate planning, Jim's presentation focused on getting help that we need from professionals to organize our end-of-life affairs, accountants, lawyers, other professionals, to help us get ourselves organized. Today, he's going to focus on the documents that guide the management and disposal of our assets and belongings after we die. He will help us unravel the mysteries of wills, trusts, bequests, insurance, and the papers that will guide our personal representatives. And that's the new term for executor. That's the Massachusetts term. I've learned something hanging around with Jim. So That's it, an introduction, and now Jim will speak for himself.
Thank you, Nancy and Carol, and I'm really glad to be here at Brooksby Village. As Nancy says, my parents were here, and I think it's a great community, and it's good to see all of you here. As Nancy says, do raise your hands or something if you have trouble hearing me. I want to try to be aware of that. I also wanted, last time I forgot to make one introduction. In the front row here is my paralegal, who has the same last name as me because she's my daughter. So this is Hannah is here helping out with the presentation. I will take a break in about a half hour just so you can stand up and stretch. There's a lot of information to pack into a relatively short amount of time, and then we'll leave time for questions at the end. With that in mind, you have handouts. The handouts give an outline of what I'm going to talk about today. And in case you haven't noticed, they're printed on two sides, so you'll flip over to the back about halfway through. Last month, we talked about, in addition to the professionals, we talked about the fiduciaries, the people from your life who you name to help you with the process, often friends or family members or professionals. As I go through the documents today, I will sort of match up. When I talk about a document, I'll talk about who the fiduciary is. And on the handout, you see again the definition of fiduciaries, but the emphasis for that word is trust. You are naming someone who you trust to express your wishes and carry out your wishes in your estate planning. A standard estate planning package, although things aren't often completely standard, but a basic estate planning package is what I'll be talking about today. And it's a set of documents, most of them prepared in legal form, but some others not necessarily. It includes joint bank account cards when you open a bank account or things like that. But a standard estate planning package of documents that would be done by an attorney has what is in your outline here. There's one grouping of documents that provide for management while you're still alive, and that's what's on the front page, and that's what we'll talk about first. Then there are other groupings that provide for both while you're alive and after you die, and another group just after you die. So I'm going to start with the documents that are in effect while you're alive but need help for some reason. And the first thing is called a power of attorney. Now, as I mentioned last time, you name a fiduciary, someone who you trust, as your attorney in fact. Attorney in fact is different from an attorney at law. An attorney at law is someone with a license who can represent you in court. An attorney in fact is someone who speaks for you, who can sign your name to a legal document. They don't have to have any kind of license. What you want is someone who will carry out your wishes. It's often first your spouse, second choice your children, or some other family or friend. The power of attorney is a written document that you sign where you name this attorney in fact, the person who can sign your name to a legal document to manage your money or property. They can sign any financial documents and bind you. The simplest and probably most common use for a power of attorney is to deal with your money. If you can't get to the bank and you want your son or daughter or friend or spouse to get to the bank and get your money out, manage your accounts, you bring the power of attorney to the bank and they will let your attorney in fact manage the money. That's the most common use. The attorney in fact, if you give them the power, can also sell your property, file tax returns, give gifts, whatever power you give them in the document. There are different ways to write the document, but when we're talking about estate planning, the most common is a general power of attorney. A general power of attorney basically says, anything that I could do with a legal document, this person can do. This person can go to the bank. This person can sell my house. This person can file tax returns, as I said. A general power of attorney usually starts with, they can do anything in my name. But then it goes on to name a lot of different things that they can do as well. There's a reason for that, and that's that often, if you bring the document to someone, they want to see not just the general power, they want to see they can manage my bank accounts, they can file my tax returns, they can do all these other things. So what I do and what I will see other estate planning lawyers do is you try to anticipate everything that you might want to do under a power of attorney and put all those in the documents. And over the last several years, my standard powers of attorney have gone from about 4 pages to about 10 pages, as you try to think of different powers that an attorney in fact might want, and that someone sitting across the desk is going to say, well, you got to show me in here where it says you can do that. So then you find that paragraph where it says you can do that. Other than a general power of attorney, you can also do a limited power of attorney. A limited power of attorney says this person can do anything from one thing to lots of things, but not everything. So a limited power of attorney might simply say they can manage one bank account, one piece of property, can sell one house, might have limitations like that, might have time limitations, can only do it for a limited time while I'm away in Europe, can only do it while I'm in the hospital or until a specified date. So again, the limited power of attorney can be either limited as to the type of management they can do or the time frame. A power of attorney can also be effective immediately when you sign the document. If the person you name has that document, they can then go to the bank and manage your money. Or you can do, the law allows for what's called a springing power of attorney that springs into life if you become disabled. And that sounds like, since we're talking about doing a document to allow managing your property if you're disabled, in principle that sounds like a good idea. As a practical matter, a springing power of attorney is often not a practical solution, because if you say in the document, this power of attorney is only effective when I'm disabled, and then you become disabled and your daughter goes into the bank and is sitting there across the desk from the bank officer's going to say, prove to me mom is disabled. And that's often not a practical solution to things, although the law specifically allows it. A middle ground that I use and a lot of other lawyers use would be, you sign the document now. It's not a springing power of attorney. The document itself would say it's effective now, but you have someone else hold on to the document. And often I will do that with an instruction letter from the person saying, release it to my daughter if she brings you a letter from my doctor saying I'm disabled. So then you skip the step of having to prove you're disabled at every step, but you keep the document protected until it is needed. And one of the reasons for that is there is a danger in any of these things, as we talked about fiduciaries last time. If you're doing a general power of attorney that says this person can sign my name to any legal document, there's always the potential for abuse of that document. And you want to try to do something to avoid that. Give me one moment, I wanted to, okay. You will also often see in a power of attorney the word durable, and someone even asked about that last time. The word durable in a power of attorney just means it's still effective even if you still become disabled. Until many years ago, you could not do a durable power of attorney in Massachusetts. A power of attorney ended if you became disabled, which makes it not very useful. Massachusetts amended the law to allow for a durable power of attorney. And I tried to think in preparing for today of when you wouldn't want a power of attorney to be durable, so I can't really give you an example. The word durable is often in the title. The word doesn't have to be in the title. There will be a phrase, and the law specifically sets out a phrase saying this power of attorney continues after my disability. So that's what the word durable means. You will see most powers of attorney are durable, either using that name in the title or just having the phrase in that says it continues if I'm disabled. You can name in your power of attorney, you can name more than one person to act. You can name people to act jointly or act individually. If you have two children who you want to be able to do things for you, you can name them both and specify that either of them can act or they can act jointly. You can also name people to act in order, a first choice. If that person's not available, then a second choice. And especially if you're naming people who are of your generation or older, it becomes more important to name second or third choices, unless you are absolutely certain that you're going to be able to get to the lawyer's office the day after something happens to that person and redo. It's always best to try to plan for different possibilities and to name ahead of time first choice, second choice, even third choice as you get into people in your generation or older. In addition to allowing for management of the money or property, a power of attorney can sometimes avoid, not always, but can sometimes avoid expensive or difficult court guardianship proceedings. If you become disabled and you have not done the power of attorney, and someone needs to be able to control your money or property, they have to go through a probate court proceeding, prove that you're disabled, prove that have the court appoint the right person after potential input from all of your family members. If you do the power of attorney, usually you can avoid that and just have the document. Sometimes there are some proceedings that still would require a guardianship, and in your power of attorney, you can nominate a guardian. So you say, if I become disabled and need a guardian, this is the person I want, and usually it's the same person who you've named as your attorney in fact. So it has the advantage of allowing for management now without a guardianship and allowing you to designate the fiduciary who you want if a guardianship is necessary. One important thing to remember about a power of attorney as we talk about estate planning is the power of attorney always expires when you expire. Power of attorney is not effective after your death. There is a little provision in the law that says if your attorney in fact doesn't know that you have died, then the actions that they have taken after your death are valid. But that's that limitation. A power of attorney is not valid after you die. There's just a little protection for people who take action after you die without knowing that you're deceased. So, power of attorney is effective only while you're alive, but it allows for management of your property while you're alive. The next thing to think about while you're alive is your healthcare decisions. The document that allows someone to make your healthcare decisions for you is called a healthcare proxy. And the fiduciary who you designate to make your decisions is a healthcare agent. And last time we talked some about what to look for in that. Just briefly, it is sometimes the same person as you'll name in your power of attorney, sometimes different people. You're looking for different skills, different interests, different willingness. This is someone who, if you cannot make or communicate your own medical treatment decisions, you're saying, this person can make those decisions for me. Ideally, you want someone who would know what your wishes are, make the same kind of decisions you would. And doctors are actually legally bound to follow those directions as if the directions came from you. So as long as you are competent to make and communicate your own decisions, you can give directions to the doctor. I talked about a springing power of attorney. The healthcare proxy law is better on this. The healthcare proxy is not effective until a physician makes a written determination that you can't make or communicate your own decisions. So there's no reason to hold that aside or anything like that. There's no reason to protect the document. The healthcare proxy has no effect as long as you are well enough to make your own decisions. But as long as your doctor determines that you can't, then the healthcare proxy comes into effect and your healthcare agent can make those decisions the same as you would. Healthcare proxy, I mentioned in the powers of attorney, you can name joint attorneys, in fact. In a healthcare proxy, you can't. You name one, you can name an alternate, but it can only be one at a time. So in a healthcare proxy, you decide your first choice on making decisions, and then if that person can't do it, who your second choice is. Just like with the power of attorney, as I said, the older the people you're naming are, the more people you may want to name, but do name alternates. The law specifically says that your healthcare agent can make decisions on life-sustaining treatment, make decisions on your end-of-life issues, subject to any limitations that you may put in the document. So if you don't want your healthcare proxy to make those decisions, or if you want to give specific limitations, you can put those in the document. Otherwise, the person who you name has that authority. That means that it's important for you to talk to the people who you name, and I'll talk about some other documents as well, but it's important for you to talk about the people who you name so that they can make, hopefully, the same decision that you would make if you were still alive and competent. And the law specifically says that the healthcare agent is supposed to consider what your wishes would be, what your religious views are, and the information, the medical information they get from the doctors, and make the decision based on all of those things. Another thing that's important with a healthcare proxy, and more so than with the other documents, is to keep track of what you have done in your healthcare proxy. And a reason for that is a lot of these other documents you're going to really look at, you're signing a formal document. If you go sign a will or a trust, you're in a lawyer's office, there are witnesses there, you'll know that what you're doing is really important. In a healthcare proxy, I find sometimes people don't appreciate the legal importance of it. And that can be when you go in the hospital, when you're admitted to a hospital, the hospitals are required to suggest that you sign a healthcare proxy. They have the forms there for you. They'll witness it. They'll give it to you to fill out. They'll witness it. And that is your healthcare proxy. And it's effective from that day until you revoke it. The danger is that you're not recognizing necessarily that you're signing a legal document designating this power forever until you revoke it. You may be just thinking about who drove you to the hospital that day or something like that. So the warning is pay attention. If you've signed a healthcare proxy and you've signed it thinking about that particular situation when you're there for your tests or your surgery or your brief hospital stay, and that's not who you want to be your permanent healthcare agent, pay attention, revoke it, do a new one so that that doesn't happen. Once it gets in the hospital's records or your doctor's records, that is your healthcare proxy until their records show it's revoked and they get a new one. Another document is called an advance directive or a living will. Now, a living will, don't confuse it with a will, a last will and testament that I'll be talking about. But a living will or an advance directive is a written expression of your wishes on treatment. Most commonly, this expresses your wishes on whether you want artificial life-sustaining treatment if you become disabled and you're not expected to recover. But it can express your wishes on a lot of different things. Massachusetts does not recognize a living will or advance directive as a legal document. I understand that some states do. Massachusetts does not. However, it can still be, it's not a binding legal document. However, it's still really important for a few reasons. One of them is guidance to your healthcare agent, the person you name in your healthcare proxy. Another is guidance to your physician, because sometimes they will be involved in these discussions. And even occasionally, you hear about court disputes about whether treatment should be continued or not. Every once in a while, one of those comes in the news, and the courts are making a determination. And if you have signed a document saying this is what I want, or this is what I don't want, the court's function is to determine what you would do if you were competent, and that signed document is very helpful. So whether it's called an advance directive or a living will, it can be important and it can be very useful to have your wishes in writing for the guidance of your healthcare agent, your doctor, or the courts if that happens. I understand in some later sessions in this series, there will be discussion of a document called 5 Wishes. Have any of you seen that or used that? Okay. So the 5 Wishes document is, part of it is intended to be and is valid as a Massachusetts healthcare proxy. So there is a page there that if you fill it out and get the witnesses, it is a legally binding healthcare proxy. The rest of the document is not intended as a legally binding document, but it's useful for a lot of the same reasons that I said on the advance directive and the living will. This says what you want. Now, they're not legally bound. People are not legally bound to rub oil on your head if you've asked for that, or to play Beautiful Savior at your funeral if you've asked for that. But it is useful for your family and the people who are carrying out your wishes to know what your wishes were. And actually, I did that. I sat with both of my parents at different times and got their wishes, and I found that very useful and very comforting. So although this is not a legal document, it's not something that a lawyer will probably prepare in your estate planning, it is something that is a very useful thing to look at and think about. The next thing I'll talk about, the next category, and you can flip over the page on your outline, is documents that are effective both during your life and after you die. And the first is joint ownership. Joint ownership documents are not something that's usually going to be done as part of your legal estate planning package, but it's an important part of your planning, because if you establish joint ownership of anything with anyone, that overrides anything else that you've done. It overrides your will, it overrides your trust, If you open a joint bank account with somebody else's name on it, when you die, they own that account. If you have real estate, and as I said last time, many of you here probably won't own real estate because at Brooksby Village, you don't own real estate. So if you sold your house and moved in here and you don't own other real estate, this isn't an issue for you. If you still own real estate and you have that in joint names, the same thing. The joint owner of the real estate becomes the owner when you die, no matter what you've said in a will or trust or other estate planning documents. Joint ownership allows people to have, an advantage is it allows people to have access. A joint bank account allows someone to have access to your money right away, even after a power of attorney has expired, after you've died and before probate is done. Those are good. But there are some warnings with that also. When you add someone's name as a joint owner of a bank account, they have access to it right now. So where I talked about fiduciaries, you're putting a great deal of trust into that person. Even if that person is completely trustworthy, there can be other events that you don't anticipate. Could be outside issues if they get divorced. If you put your daughter's name on a bank account and she gets divorced, that's an asset that at least has to be reported to the probate court. If they become disabled and apply for public benefits, they have an asset. So joint ownership is a good estate planning mechanism in that it's easy and straightforward and avoids probate, which I'll talk about in a moment, allows property to pass immediately on your death, but there are dangers too. You want to make sure it fits in with the rest of your estate planning, and you want to do as much as you can to anticipate what might happen if there's an issue. The other thing with joint ownership that I mentioned last time is sometimes people will put especially money into a joint bank account so that their son or daughter can help manage and pay their bills. And they may be thinking when they do that, that's great, they can pay my bills, and then when they die, they'll split up the money. But that is not the default legal ownership. When you establish a joint bank account, your agreement with the bank says, when I die, this other person is the owner. So if you're doing this with the intention that, the good intention, that if I die, the other person will be able to use whatever money is left over to pay my bills, to pay for my funeral, that's great. That's a good way to do it. But if your intention is also that anything that's left over after that gets split between my kids or goes according to my will, you should put that in writing in a separate document. And we will take a 5-minute break now where you can stand up and stretch, and then I'll pick up from there. So continuing with the other common estate planning document that's in effect both while you're alive and after you die, or can be in effect both while you're alive and after you die, that would be a trust. So a trust is a legal document, a legal agreement, where you name a trustee or trustees, fiduciaries, using that term again, and again the definition's on the front page, who will manage your money or your property, either for general purposes or for specific purposes. There are a couple basic kinds of trusts. One is a revocable trust, saying you can change it at any time. By saying it's revocable, it also means usually it's amendable. At any time you can change your trust while you're alive, as long as you are alive and competent. And that's the most common kind of trust we're talking about in estate planning, and I'll talk in a moment about different reasons for doing that. There is also a kind of trust called an irrevocable trust. It can't be revoked. Once you put the property in there, you can't take it out, you can't change it. That is most commonly used in Medicaid or mass health planning for nursing homes, and that's beyond the scope of what we're talking about here today. And with the continuing care retirement community model at Brooksby, it's not as applicable to people here. So the most common kind of trust we're talking about here is a revocable trust. And usually in estate planning, it is in English, it's a living trust. In Latin, it's an inter vivos trust during your lifetime. So it's established while you're alive, and it's effective while you're alive, and it can continue after you die. Some will say, after I die, everything's distributed according to this formula. Some will say, after I die, property is maintained in trust for this amount of time, or until my children reach this age, or whatever. You can also do a testamentary trust, which is a trust established in your last will and testament. But for while you're alive, the most common estate planning tool we're talking about is a living trust. And again, often you are the trustee, you manage it as long as you're alive and competent. But in there you provide for successor trustees. And again, you want people, hopefully younger than you or more people, you say, who's going to take over when I can't do it myself? People often come to me for estate planning and say, I need a trust. And I ask them why. Sometimes it's because someone they know just did one. Sometimes they've been listening to financial planners on the radio. I always need to know more about why they think they need a trust and what they're trying to accomplish with it. There are many common and very good reasons for doing trusts, other than my friend just did one, or that guy on the radio said to do it. The first is planning for managing of your assets for your minor children, probably not too many of those here, although our president has a minor child, or your grandchildren, or for young adults who are legally of age but may not be ready to manage the amount of money or property you'd be leaving behind, or for people who aren't capable, spendthrifts, someone who can't be trusted with the money, adults who aren't competent because of some medical issue or substance use issues. You can set up a trust that provides for management of your money and property while you're alive, after you die, to benefit those people. Another reason for establishing a trust is giving someone else the power to decide how to divide up your assets if you get to the point where you can't do it yourself. Some of the things we talked about last time, you can, in your trust, say, this is for the benefit of my spouse, my children, my grandchildren, a charity, and you can give the trustee some discretion, the same discretion you would have while you're alive. While you're alive, you can decide how much money to give each of your kids, each of your grandchildren. If you get to the point where you can't do that yourself, in your trust, you can give your trustee that same discretion. And it might be to divide things up. Sometimes, as I mentioned last time, people want to make sure things are divided exactly equally no matter what. Other times, people may want to take into account special needs, whether it's medical needs or financial needs, disabilities, how close you are to your children, which children have been good to you, which children have been bad to you. you are giving the trustee, you can give the trustee, oh, and also if you have a child who's graduated from college and one who hasn't started yet, you may want to even that out. You can even things out. You can even out past distributions. You can give your trustee the power to do the same kind of things that you would do while you were still competent, to make those decisions on how best to divide up your property among your family, among your favorite charities. They can consider information that you didn't have at the time of the trust, and they can make those decisions. Another reason for doing a trust is reducing or eliminating estate taxes. And as a reminder here, I did put in what the taxable estate limits are. Massachusetts has an estate tax for estates over $1 million, and the federal is, I skipped the 2018 thing, we're almost all the way through December. So it's $11.4 million starting in a couple weeks. You can leave without estate taxes. And anything that goes to a spouse doesn't have estate taxes, but if you have an estate that is worth more than $1 million, if the combined estate of husband and wife is worth more than $1 million, it is sometimes advisable to do trust planning to try to save on estate taxes so each of the spouses gets their $1 million exemption. Hope that's not too confusing, but the key thing to remember is avoiding estate taxes or reducing estate taxes is one of the common valid reasons for doing tax planning. If you're going to leave, you yourself if you're single, or you and your spouse if you're married, if what you leave behind is worth less than $1 million, not a consideration. If it's worth more than $1 million, it is something to at least discuss and think about. If you do a trust, one of the most common issues is people forget to transfer their assets into the trust. You can do a perfect document that says exactly what should happen, but unless you move your bank account, your real estate, your investment account into the name of that trust, the document is meaningless. So one of the things that you need to do when you're doing this, for whatever valid reason you're doing the trust, you should look at all of your assets, what you've put in joint names, what you've designated beneficiaries on, which I'll mention in a moment, what's in your own name alone. Make sure everything together divides things up the way you want. You may still want to have a joint bank account with one child who you want to get more, or that may not be what you intend. You may be thinking that when you do the trust, everything is going this way. If that's what you're thinking, make sure everything goes into the trust. And make sure you remember that every time. If you close out one investment account and open a new one, make sure you do that in the name of the trust. Another thing, not quite as common for you here many of you have sold your houses, but sometimes banks, when you're refinancing, don't like property in trust, so they say you have to take the property out of the trust, and then you sign the mortgage, and you have to remember to put it back in the trust. The key is, if you're doing a trust as your major estate planning tool, figure out how you want things divided, and make sure, look at all your assets. Part of your homework from last time was to look at all your accounts and see how they're titled. Make sure that everything fits together the way you would want, so that when you die, everything gets divided up the way you want. Next, after you die, the thing that probably everyone here should do is a will. Fancier terms, a last will and testament. A will speaks at death. It affects only the property that is in your name alone on the day you die. Whatever is in joint names is not affected by your will. Whatever you have actually put into the name of your trust is not affected by your will. Whatever you own with just your name on it is what's controlled by the will. In the will, you appoint a fiduciary, there's that word again, now called a personal representative, as Nancy mentioned. Used to be called an executor if it was a male, or an executrix if it was a female. But now personal representative goes for anyone who you appoint as the fiduciary in your will, or anyone who the court appoints if you don't have a will. You're appointing a personal representative to follow your instructions, to carry out your wishes. Last time we talked about some of the skills you're looking for in that person. Sometimes that work can just be routine. Other times it can have some of the same kind of discretion that I talked about in a trust. You can give your personal representative some decision-making power over how to divide up property and what to sell and what to keep. When I say everyone should have a will, even if you have decided to do joint ownership or a trust as your primary way of dividing up your property, you should still do a will just in case there's some piece of property that you forgot to put into your trust, or that you inherited last week, or where there is some question of the legal documentation that you've done. You do what's called a pour-over will that essentially says, everything I have left in my name alone, you can use it to pay the bills, and whatever's left after that goes into my trust. So if your trust is your primary estate planning document, that's the way you account for the possibility that you have forgotten to put something into the trust, or again, have gotten something that you didn't get a chance to. So you're always going to do a will as part of your estate planning, even if the trust is your primary mechanism. You do the will that says everything else goes into my trust. Another thing to think about with a will is personal property. Last time I did a little law school thing on the difference between real property and personal property and intangible personal property. Now I'm talking about tangible personal property. It's your stuff. It's your things you can touch. It's your car, your clothes, your jewelry, your antiques, your family heirlooms. If you want to do something that is legally binding with your personal property, it should go in your will. If you have some particularly valuable jewelry, furniture, family heirloom, and you want to make sure that there's an enforceable plan for what happens with it, you should mention that in your will. The middle ground is you can do and my wills and most wills I've seen allow for the possibility of a list of property which is not necessarily legally enforceable and which you can change without legally changing your will. But you are counting on, and you say in the will, you're counting on your personal representative to carry out your wishes, and that's usually going to work. So your most valuable assets, put in the will. Next most valuable, do a list, have some way of doing your plan on what's going to happen. Because often the assets that may not have so much tangible value may be especially meaningful for some people in your family, and some people may be offended or upset if they think things aren't going fairly. So do try to account for that. Anything that's in your name alone is what's managed in your will, and that's all that's managed in your will. It's sometimes called probate property. That's what's going to be managed under the supervision of the probate court. But that is not, sometimes people think probate is horrible, and there are some books and some of the TV financial planners who will try to say that. It is not always the wrong solution. For one thing, in 2012, Massachusetts adopted the Uniform Probate Code that's in effect in many states, and it simplified probate procedures a lot. In most cases, you can have your will approved by the probate court and your personal representative appointed within a few weeks of your death, as long as everyone in the family is on the same wavelength. So it's not something that has these horrible delays or horrible costs. The court no longer requires, well, let me go back to one thing I didn't say on the trust that I should. Another advantage of a trust is it avoids probate. So now I'm talking about probate. Another reason for doing a trust is it avoids probate and it maintains your privacy. The trust does not get filed in the court unless there's a legal challenge over it. So in a trust, a reason for doing a trust is to avoid going to probate and avoid making your distribution of your property a public record. A will, by definition, is going to become a public record when it is filed in probate court. In theory, anyone can walk into the probate court in Salem, look up your name in the index, and ask for your file and see what your will says. Probably isn't going to happen that often, but that can happen. So for those who are concerned with that, that is a valid reason for doing a trust. Other than that, again, probate is not that bad. It is relatively easy in Massachusetts now. You can do in your will, you can change your will anytime as long as you are alive and competent. Just like the revocable trust, either of those things. If you change your mind on who you want to name as your trustee or your personal representative, you can change your trust or your will. If you change your mind on how you want your property distributed, you can change your trust or your will. One more thing I want to mention is in your will, or maybe your trust, as you're planning for the future, you may want to provide for your pets if you have pets. As I said last time, pets in Massachusetts are tangible personal property, the same as a chair. So that's the way the law looks at them. It's probably, if you have pets, not the way you think of them. So you can, in your trust or your will, say who you want to care for your pets, and you can also leave some money or some provisions to that person for taking care of your pets. Continuing on with documents that are effective after you die, you can do a beneficiary designation on many of your assets. So beneficiary designation says who gets money or property when you die. Most common example is probably life insurance. When you take out a life insurance policy, you say who benefits. The policy will have some defaults. If you don't name someone, they'll decide. But as long as you name who the beneficiaries are, and you can name alternates as well, it goes to those beneficiaries, again, no matter what you have said in your trust or in your will. You can also designate beneficiaries often on retirement accounts and on investment accounts. Again, those trump anything that's in your, should I use that word? Those supersede anything that's in your trust or your will. So pay attention to who you have named as your beneficiary and make sure that fits in with your overall plan. And it might be fine to have different people on your life insurance from your will if that's what you really want. But that's a way of avoiding probate, and it's something that's you can change as long as you're alive and competent. But is separate from the other documents that we're talking about. Some institutions will also allow transfer on death or payable on death accounts. So rather than establishing a joint bank account, you can do a bank account that's yours until you die. It says who gets it, and it avoids probate. So that's a way, all of the beneficiary designations are a way of both avoiding probate and avoiding some of the problems that you get with joint ownership, and a way to maintain privacy. Next thing, I thought of asking for a show of hands, but I don't want to embarrass anyone. I have sometimes heard people say that if you don't have a will or a trust or designate beneficiaries, the state will take your money. That's not true. Although I'm sure the state would like to have your money and certainly would put it to good use, the state will not take your money. The accurate form of that statement is that if you don't do a will or a trust or a beneficiary designation, the state will decide who gets your money. What that means, if you die intestate without a lawyer, without a will, without a last will and testament. So if you die with a valid will, you die testate. If you die without a will, you die intestate. The law says who gets your property. And it's basically your closest relatives, and it's a first choice, second choice, third choice, whatever. If you do not do a will or a trust or designate beneficiaries, you are saying that that law, that state law, is what will apply, and that's who will get your property. So the state won't take your money, but the state will decide who gets it. Also want to mention documents after death, two other specific Brooksby Village documents, which I mentioned last time, so I'll just say quickly. One is your entrance deposit refund form. For those who were here last time, I gave you homework to try to find out what you've done, because you have three choices. One choice is you name the people who get your entrance deposit after you die. Another choice is it goes to your estate, which means it's going to go according to your will or to the state law if you don't have a will. And the third choice is it goes to your trust. Take a look at what you've done, make sure it fits with your overall scheme. That's going to be a significant asset for the people in this room. Make sure you know what you've done and that it's what you want. The other is a permission to enter form that says who can enter and clean out your apartment after you die. Make sure you do that, because otherwise security will lock the apartment. So those are the two specific Brooksby Village post-death documents I want to make sure you're aware of. A last issue that people sometimes wonder about, and should, is how much does all of this cost? So I did some research into what other lawyers charge, and some law firms do put their fees right on their website, and I'll give you a range. First of all, for single people who are doing a will-based plan without a trust, so the other basic documents I've talked about, but with a will and no trust, I see a range of $800 to $1,500. For single people who are using a trust in addition to the other documents, I see a range of $1,200 to $2,500. Married couples, a will-based plan without a trust, a range of $1,800 to $3,500. Married couples using a trust, a range of $2,400 to $6,000. So that's an idea, and I mentioned different reasons for doing trusts or not doing trusts, but that is also a valid reason because it adds expense now, and it adds some complication to your life now in terms of transferring your assets into the trust. And by the way, my fees would be in between those extremes. Should you do estate planning? Yes. Clearly, yes. Should you have a trust? Maybe. There are good reasons for doing it and good reasons that you might not. Balance your priorities and figure out what's the best plan for you.
Well, we definitely want to give Jim a great big thank you for his work, and then I want to say a couple of things. We are a lot more informed now than we were an hour and a half ago. That's really great. Well, I just want to say that we will host Jim again in May when he will discuss legal documents for healthcare decisions. But in the meanwhile, we have a number of other programs with different speakers about different topics. Among the topics are responsibility papers, which will happen next month, January, on the 21st, and our very own Bob Vincent will march us through what we need to do with all the papers that are related to our lives here at Brooksby and tidy things up. And he will talk about things like financial records, insurance, and different papers. He'll give us tips on organizing them. That's great, because he's one of the most organized people I know. And if you know him, you know he's organized too. So that will give us a list of homework to occupy our long winter nights after we talk with Bob on January 19th. So mark your calendar now and plan to go to that one, and we will march through the calendar together. We're Brooksby together. Now, last point, make Carol Bortman happy by filling out your evaluation. She's looking to beat the percentage of last time. So help her out and be sure you put that evaluation in. And I think everybody's going to give a big cheer to Jim and to the microphones, which did pretty well this time. So thank you, Jim. Thank you. Thank you.